All rise. The Court of Appeal and for the 5th District of the State of Florida is now in session. The Honorable Richard B. Orfinger, Chief Judge presiding. All persons having business before this court draw near, give attention, and you may be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, and be seated, please. Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal said, I'm Judge Orfinger, and I'm joined on the bench today by Judge Lawson and an Associate Judge from the Circuit Court, Judge Rob Rouse. We're happy to have Judge Rouse join us on the court today. If you have a cell phone, we would appreciate it if you would silence it so that the parties are not interrupted during their arguments. We have 3 cases today. I suspect that we will take up the first 2 and then take a break. And at the time that we have a break, the attorneys will be invited to join us in the attorneys' lounge if they'd like to have a chance to visit. We'd always like to have a chance to say hello. On our first case this morning, which is Bishop versus R.J. Reynolds, if let's just make sure that we understand how we'll proceed. I assume you're representing the bishops? Okay. So you'll go first. Tobacco, you get to reply and address your cross-appeal. You'll get rebuttal and then an opportunity to, at the same time, address their cross-appeal, and then you'll get a rebuttal on your cross-appeal. That seemed to be a fair way to do it, so you can tell me how you would like to reserve your time, and I will do my best to set the clock accordingly. So with that, we'll go ahead and call the first case, Bishop versus R.J. Reynolds. Good morning and welcome.
Thank you. Good morning, Your Honor. I did want to ask a little bit of clarification. Are we still dealing with the 20-minute time frame?
Yes.
Okay. Then I would like to reserve 10 minutes for addressing the cross-appeal, if I may.
Okay.
As Your Honor stated, my name is Celine Humphreys, and I represent the plaintiff. It is my understanding that this appeal is the second Engel progeny appeal or case that has come before this court. The issue in this particular case is a summary judgment motion in which a trial court specifically held as a matter of law that the plaintiff could not prove class membership, satisfaction of the class membership definition. Now, a key issue, as always, in dealing with a summary judgment is the fact that summary judgments should be used exceedingly rarely. So both parties have pled or asserted a conditional issue. We've asserted as a conditional issue, upon reversal of the summary judgment motion, a discovery order. Defendants assert upon reversal that this court should look at the meaning of Engel. In other words, what did the Florida Supreme Court mean when it stated res judicata effect would be given to findings regarding, I'll just say, the tobacco companies or the defendant's conduct as a whole. Now, 2 of those issues, and I understand the rebuttal will be addressing the meaning of Engel, but that argument and the summary judgment argument both relate to some core facts from the Engel litigation. And although I only have 10 minutes, I want to briefly highlight those because I think some of it got lost in the mix of the briefing. You always see that when you're preparing for oral argument, what didn't really come out clearly enough. This case began in 1992 because that's when Mr. Ramsey died of lung cancer after years of smoking cigarettes manufactured by the defendants. 1994, the Engel class action was filed. The Engel class action was filed as a nationwide class action. Specifically, the definition included all United States citizens and residents. Also in 1994, the trial court certified that class action, and that's when notice first went out, October of 1994. Defendants then appealed the class certification to the 3rd District Court of Appeal. The 3rd District looked at the class certification definition and made only one change. It narrowed the scope. So instead of being all United States citizens and residents, the 3rd District held that the definition should instead be all Florida citizens and residents. 1998, July, the trial finally commences. It commences in 3 parts, or it's envisioned as 3 phases. The first phase focuses simply and solely on core issues relating to defendants' conduct. and to the harmfulness and addictiveness of cigarettes in and of themselves. That's what's called phase 1 in our briefs and in the cases. There were findings that came from that. Phase 2 actually had 2 parts. The first part addressed those 3 particular class representatives and their particular claims for compensatory damages. Phase 2 was all punitive damages for the entire class. After about a year of litigation, phase 1 lasted about a year, included 87 witnesses, and the jury found against the defendants on every question that was put to them. I'm going to skip a lot and go to 2006. That's when Engle was issued. Now, there's 2 important things that Engle talks about a lot of decisions, but there's 2 important things that the Florida Supreme Court states in the Engle decision that we're going to be focusing on today. 1, it affirmed again the class membership definition, and that relates to the summary judgment motion. The only change that it made, well, first of all, when it affirmed the 3rd DCA's restriction and said, okay, we're fine, narrow to Florida citizens and residents. The only change made by the Florida Supreme Court regarding that definition was to recognize that there cannot be an open-ended class. You have to close the window at some point. So that date for closing the window was set as November 21st, 1996.
They said that was a cutoff date, didn't they?
A cutoff date is the exact language, and I'm going to be focusing on that on the summary judgment. Otherwise,
as it relates to the class, it was all citizens and residents and their survivors.
And their survivors.
Oh, you interpret that really to mean citizens or residents. They interpret it to mean citizen and residents.
That's another point that I discerned last night while preparing. That was what we debated below, and that's what we argued in our initial brief, that whenever the word "and" is used, grammar rules say it's both categories, boys and girls, judges and lawyers, it's both. And that the trial court wrongly limited it to residents only. They've abandoned that issue on appeal. If you read their brief, their answer brief, they no longer focus on the distinction. So right there at the get-go, the first question regarding what does the class membership definition mean, there's no dispute now before you. We agree. There is no dispute as to whether it's citizens and residents or. So that reason right there we can stop. That is a basis for reversing the summary judgment motion because the trial court ignored that fact. Now, just jumping right into the summary judgment motion, there are 2 other arguments that have been made by the defendants. And as a backdrop, our argument consistently before the trial court and on appeal is there's nothing confusing about this definition. The words mean what they say. But the arguments that were made below and are fleshed out here are twofold. 1, the defendants assert, well, it's not really a cutoff date. It's a date certain. It's not a window closing. On that date, November 21st, 1996, you had to qualify as a member of this class membership definition. The second argument they make is, building on that, since it's a date certain, they say, when somebody visits out of state in order to pass away with their loved ones, that is relinquishing your domicile. Both of those arguments fail, and I think I can do a better job of highlighting why.
First, Humphreys, let me just
Yes, sir.
stop you. I think I will be inclined to give both sides an additional 5 minutes because I think these are issues that we really need to give you both plenty of time to talk about. Well, maybe not plenty of time, but 5 more minutes worth.
Well, the last time I was here, it was 2 hours, so anything short of that's wonderful. Last time I was here on an Engle appeal. Diving right into the class cutoff date. As your question brought out, you know what, if you really read the Florida Supreme Court's discussion of this cutoff date, it is clear that they are not saying a date certain. There are 2 pages that were not cited in their brief, and I think the court really needs to look at those to put this issue to rest. They're pages 1255 and 1275. Again, that's 1255 and 1275. Both points in the Engle decision, one is the initial holding that is summarized by the court itself, and second is the actual discussion. The court makes clear what it was worried about was an open-ended class, a class where there was no window closing. So it simply said, we're going to close the window at some point because you gotta. And the window closes at November 21st, 1996.
Well, does the language that I see in Engel, the critical event is not when an illness is diagnosed, but when it manifests itself. I mean, is that the date, assuming that that date is prior to the November of '96 date, is that the date that you would contend either put you in or out of the Engel class?
You've just identified another debate we have. That language is specifically ignored by the defendants. I agree with you. If, in this case, there is no dispute in the evidence that Mr. Ramsey was diagnosed with lung cancer, suffered from lung cancer, was treated for lung cancer, all while he squarely resided and had his legal domicile in Florida. You'll find no debate on that in the papers at all. What they want to argue...
The disease manifested itself when he lived in Florida, which is the triggering point that the opinion notes, right?
Well, yeah, the triggering point does note that as far as when the timeline begins, yes. But for the class membership definition, it also states specifically that that must have occurred before 1996. And that existed here. So there has been no question. Now I think I'm understanding your question, maybe. In some other arguments before trial courts and in another appellate case, there has been an argument in a summary judgment motion, well, this manifested so much earlier than 1996 that you didn't bring your cause of action soon enough. This case doesn't, they never asserted that, and we're not arguing, how long ago did the disease manifest itself. The only thing that we're disagreeing on is, was this man a citizen and resident in Florida at the time, in time to qualify for the 1996 date, either suffering from the disease or dying from the disease. So that's where I thought initially you were going. The facts that you just pointed to relate to the fact that there's no question that Mr. Ramsey suffered from and was treated for lung cancer in Florida while a resident, while a legal domicile, before November 21st, 1996. By arguing that this was a date certain, not a cutoff date, defendants want you to instead ignore that and focus only on the date that he died. And because on that very single date that he died, he was not in Florida, they want to say he doesn't qualify. Well, one reason why that fails is because he previously suffered timely for 1996.
So you would take this and extend it and say, even if it was undisputed and everyone agreed, both sides, that he intended to leave Florida after he was diagnosed, and maybe it's just not a few months, but a year, and leaves and moves to Idaho and changes entire voting, registration, everything, still qualifies in Florida.
Yes, and nothing in the decision suggests to the contrary. Nothing at all. Now,
Well, conversely, just so that we understand how you would frame the class, if I was a resident, let's assume I'm a resident of, we'll use his state, Virginia, and while I'm in Virginia, the disease manifests itself, and I decide, well, I think I would do better if I lived in Florida, the climate, whatever, and so I move to Florida, and it's only in Florida that maybe I find out I've now got lung cancer. Can I inject myself into the class in that fashion?
Well, initially, you're not really injecting yourself into the class because back then nobody knew about it. But as a matter of legal point, yes, you can. And the point that makes that clear is the Florida Supreme Court's discussion of suffering. The Florida Supreme Court specifically stated that all that they are focusing in the pages that I mentioned to you, particularly page 1275, their sole inquiry is to people who were suffering in the past in Florida or presently suffering in Florida, on or before November 21st, 1996. Now, to the extent you're worrying about folks flocking from other states to have qualified for a class that didn't exist yet, that's where your earlier inquiry kind of comes in to help that. There is a precursor point that at a certain point you had to have filed your cause of action once you were aware of the possibility that you had this illness. So that prevents some sort of 10-year span of somebody being diagnosed and living in Oklahoma 10 years earlier than moving to Florida. There is a certain point by which, under the statute of repose, that you would have had to file your action. So this is not... it's not some situation where we're bringing in flocks of folks, I think, if that's your concern. Another point I want to focus on, to the extent that defendants have asserted that November 21st, 1996 is a date certain, their argument makes clear why that doesn't work. Because if you notice, they say, well, here's what it should be. It's November 21st, 1996, but gosh, it doesn't work when somebody dies before that. So we'd like you to read in a new part or a new qualifier to the class membership definition. And that is if somebody dies before November 21st, 1996, instead of using that that absolute date certain, you use the date certain of when they died. Well, the fact that they have to make that stretch, have to ask you to change, that's what it is, change the definition, in and of itself demonstrates why their argument fails. The other argument that is made is, and we've touched on it a little bit, based on that, as I said, based on the argument that there's a date certain and not a closing of the window, their argument is that the fact that somebody visits out of state in order to die or pass away with their family, that in and of itself was a relinquishment of permanent domicile. That argument fails for three reasons. First, it ignores binding law of this state, including this court, a decision written by Judge Lawson, the Snyder decision, which states that in order to relinquish or lose legal domicile, that legal domicile is presumed. And to lose it, you must affirmatively work to establish a new permanent residence. Well, I mean, it's kind of mutually exclusive. It's fundamentally mutually exclusive to say that going to visit in another state to pass away is establishing a permanent resident. There's no indication here at all of that. He was not going to establish a permanent residence. He had no intent to get a voter's ID, a driver's license, register his car, get the homestead exemption, file his tax returns.
Just for me to be clear, is it your position that it really doesn't make any difference if he intended to leave or not? Is it your position that if he was a Florida resident or citizen at the time the disease first manifested itself, assuming that that's prior to the November 1996 date, that he's a member of the class, and the fact that when he finds out he's got lung cancer, he decides to move back permanently and indefinitely to, Michigan or wherever is really irrelevant? I mean, do you contend that that's relevant, or do you think that their membership in the class is a function of were they a Florida resident or citizen at the time the disease first manifested itself? If the answer to that is yes, they're in. If the answer to that is no, they're out.
No, we don't take that absolute position, and I should have made that clear. If, in this case, let's say he did not go to Virginia to pass. Let's say that Mr. Ramsey sold his home, that he moved to Virginia, that he purchased a new home, that he kept no belongings in Florida, no residence, that he obtained a driver's license, got employed in Virginia instead of Florida. If he did all of that, he would have relinquished citizenship, but also he would no longer even have a residence. Remember, residency is a lesser standard or a broader circumstance. If he didn't even have a home in Florida, he would no longer qualify. But none of that happened.
Well, but I understand. But
is that because the cause of action for wrongful death action accrues on the date of death, and so the cause of action would have accrued in the other state if he had left Florida and established a domicile and residency in another state?
In that situation, yes. If he had unequivocally, I thought I was being asked a question. If he had unequivocally established legal domicile in Virginia, first of all, the only reason we're looking at legal domicile and residence is because the class membership definition tolls the application of statute of limitations. If the evidence here was clear that there was no legal domicile for all those factors that you discussed in the Snyder decision, and that there was no residence maintained, nothing to toll the statute of limitations in Florida, and he had moved back to Virginia and passed there, absolutely. The Virginia statute of limitations would have applied and would have had to have been filed then. But none of that happened here.
Well, but how do you square that with a case you rely on, the Rerick versus R.J. Reynolds, where they say the Supreme Court required manifestation of a smoking-related disease or condition in Florida? Isn't that when the cause of action, I mean, the way I read it, they're saying that's when the cause of action accrues. And it seems to me that it would be your residency when your cause of action accrues that's determinative. And, if you happen to be in Florida, you come down to Disney World and you develop a cough and you go to the hospital and they say, you got lung cancer. and you go back home to Michigan for treatment, I don't think that makes you a member of the class. But on the other hand, if you're living here, you are diagnosed with lung cancer and then say, well, you know, I'm going to just go home. You don't think you're going to die, but you eventually do. I mean, I guess I'm having a hard time understanding that argument, but you're down to 7 total minutes, and so you may want to hold on to some time.
If it's 7 total minutes, I absolutely do want to hold on to some time. Thank you, Your Honor.
Yeah. Would you like to reserve some time for your rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes. My name is Jeffrey Michael, and I'll be arguing on behalf of the appellees in the case.
All right. Good morning, sir.
Morning. The trial court correctly granted summary judgment because the record evidence conclusively demonstrated that by November 21st, 1996, that's the date picked by the Florida Supreme Court, Mr. Bishop had removed himself from Virginia, physically removed himself back
from
to
Florida?
back to Virginia. Had removed himself from Florida, back to Virginia, the longtime state in which he spent the most of his life, in order to never return to Florida. And he actually stayed there for the rest of his life and passed away in Virginia. At that point...
So your view is that you had to, assuming that you were still alive on November the 21st of 96, you had to be a resident and citizen. And the fact that, assuming that I was a resident and citizen of Florida in 1994, and that's when I get the diagnosis of one of the Engel conditions, and then at that point I decide, I'm going to go back to wherever I was from originally, then that excludes me from the class.
Correct, Your Honor. There are 2 different distinctions at play here. One was in Rerick, which resolved that you had to be a Florida citizen and resident at the time of your manifestation. That's Rerick. The second...
Isn't that consistent with kind of the standard rule of when your cause of action accrues?
That is partly consistent with that. Here we do have a wrongful death case, and the wrongful death action accrues at the time of death. But Rerick did not exclude an additional hurdle.
But we've got cases that say that the wrongful death action, while it's a separate claim, is a derivative claim that relates back to the original negligence that was done. Maybe not for statute of limitations purposes, but for virtually every other purpose.
I'm not sure I'd say for virtually every other purpose, but this is a statute of limitations issue. And the Rerick court did not exclude what we are arguing here, which comes directly from the Florida Supreme Court statement that the class was all Florida residents fitting the class description as of the trial court's order dated November 21st, 1996. As of the trial court's order dated November 21st, 1996, and that's page 1257 of the Engel opinion. So the Rerick court was not considering that November 21st, 1996 cutoff from the Florida Supreme Court. And here, by the time that had come around, Mr. Bishop had conclusively given up his Florida citizenship and residency.
So do you agree that Mr. Bishop was a Florida citizen in August of 1990 when he moved permanently and changed his residence to Florida?
When Mr. Bishop came down to Florida in order to take a job or continue his job in a different position with Texaco, yes, we would agree that he became a Florida citizen and resident at that time.
Do you agree he was a Florida citizen when he was diagnosed with cancer in December of 91?
Yes, Your Honor.
And when he was given his dire prognosis that you only have a few weeks to live in May of 92, he was a Florida citizen then?
When he was given that dire prognosis?
Yes,
Correct, Your Honor.
Okay.
And at that point, though, when he decided to physically remove himself from Florida...
So if he had decided, if the prognosis had been, you have 1 day to live, and he decided he wanted to die in his favorite vacation spot of who knows where, somewhere outside of Florida, and he goes there and dies the next day, it would be your position that he was no longer a Florida citizen?
No, Your Honor. At least in that hypothetical, he's going to his favorite vacation spot. He is not meeting the test from this court in Kavanaugh and in Snyder of removing yourself to a new home, to a new residency. They purchased a house in Virginia Beach or obtained a house to live in. He was returning to...
Does the record reflect that they purchased a house?
I'm sorry, I misspoke on the purchase. The record says that they obtained a place to live in Virginia Beach. It's the exact residence that is listed on the death certificate.
Could be a nursing home, right?
I'm sorry?
Could be a nursing home?
I think that in this case it was not a nursing home.
Right, but under your argument, it might as well have been. It wouldn't make any difference.
As long as you were, under this court's precedence, finding what is an abode, what is a place where you intend to make your home, and you actually physically move to it with no intent to go back to the prior state, you have effectuated.
Shouldn't there be some analytical difference if the reason you don't intend to come back to your home is that you know you're going to die in a few days, rather than the fact that you intend to live out the rest, to live a reasonably long life for an uncertain amount of time in a different place?
Well, you could be tempted to see an analytical difference. However, people know that their prognoses are not certain when they're made. And
I mean, under your theory, if you know you have a day to live, wherever you choose to live the rest of your life, that one day is your new residence or citizen, your citizen there, because that's where you intend to live the rest of your life. I mean, that's sort of what you're arguing, isn't it?
Well, and we're not in a case where that sort of hypothetical is borne out.
Almost. I mean, he was told he had a few weeks to live, and he, in fact, died within a few weeks of that prognosis. On the date of prognosis, he lived in Florida, and he was still registered to vote in Florida. He still owned a home here. He still was had his driver's license here. His automobile was registered here. I mean, he left knowing that he only had a little while to live, and that.
And what
most of us, that would be, I'm going on a vacation to another state. But for him, because he only had a few days or weeks to live, it ended up being his final resting place.
I think Judge Lawson's pointing out, I guess, at least as I see it, among other things, that this is maybe the hardest case you could have picked. Short of one that just he left for a few days, he almost just did leave for a few days, right?
Well, if we remember in the context of what is happening at the time of his prognosis, we're not talking someone who decided they wanted to live out a couple weeks in Hawaii because the climate might be better. We're talking someone who came down for just 2 years, who had been a longtime resident of Virginia, came down for just a handful of years, and decided to go home. Why does that make any difference?
Assuming that, as you just conceded, that he became a Florida resident and citizen in the early 90s, I mean, it seems to me that that's like being pregnant. You either are or you aren't. And you conceded that he was. So now the question is, what evidence is there to suggest that he relinquished that capacity? Not whether he'd been here a week, a day, a year, or 15 years. We've conceded, we've all agreed that he definitely was a Florida resident and a Florida citizen. So now we're focused on, did he lose that status in some way?
Correct.
And I'm having a difficult time understanding under the facts of this case where you've got 2 weeks to live. In fact, that proves to be quite accurate. My understanding of the record was that they either rented a home or a condo or something. But would it really make any difference if he went directly to a hospital and dies in a hospital or a nursing home, as Judge Rouse points out?
Put another way, in this case, he went somewhere else to die, not to live.
Well, I would phrase it that he went somewhere else to spend the rest of his days. Mm-hmm. And all you need to know in terms of the summary judgment evidence is the specific testimony of Ms. Bishop at Appendix Tab A, Exhibit D at 69, her own deposition where she conceded that they went back to Virginia with the intent that he would spend out the rest of his days there. Now, in terms of the indicia of residency, the typical indicia like where you register to vote, your driver's license, and things like that, those are all looked at by courts to try to discern someone's intent, because it is tough to find intent. Here we know the intent, so there is no reason to revolve down to the indicia, and he had no reason to change any of that because of the dire prognosis. So the record is clear that There was no intent to ever return back to Florida once he vacated the state.
Well, getting back to to a more analytical argument, perhaps, how does your position square with the Supreme Court's specific language that this was a cutoff date? It doesn't seem like it's a date. They didn't say this is a date where you have to be in Florida breathing the glorious Florida air. It says cutoff date.
Right. And the language we would, of course, focus on is that they describe the class as fitting the requirements as of November 21st, 1996. And why was that date selected? That was the date of publication of class notice. And if you think about publication of class notice, it was done in Florida for Florida smokers. And so if you've got someone who came to Florida in 1990, got diagnosed and moved away to Michigan and is still living there as of 1996, he has no exposure to that class notice, and that would violate due process.
That's a due process claim that he or she might get to raise. How do you get to raise that on behalf of potential plaintiffs?
We're not actually raising that claim. We are creating the framework in which the Florida Supreme Court's selection of the need to be a Florida citizen and resident as of that date makes sense.
But in a death case, the personal representative could have been a resident of Hawaii, right? I mean, as of all these relevant dates, and then come back to be the personal representative of the estate. So it really wouldn't, these notice requirements aren't they a red herring?
Well, it certainly won't winnow out every single potential case where the personal representative, frankly, could be a bank in New York City or a lawyer in New York City. But it would tend to winnow out the great majority of cases where someone's survivors typically are going to be in Florida pressing the case. Now, I think if you look at what happens when there's a death that is prior to November 21st, 1996, why you need to look at residency at the time of death. If we have established that his residency changed back to Virginia prior to his death, well, it certainly could not have changed again after his death. His residency was essentially frozen as a Virginia citizen and resident at the time of death. And so when November 21st, 1996 came around...
How does that square with the language of the Supreme Court where the class certification, who have suffered, presently suffer, or who have died? So if I have suffered, if I'm a Florida resident in 1992, and there's no question I'm a Florida resident, and then I decide when the disease manifests itself and I get my diagnosis in 1995 that, I think that maybe I would do better in Arizona with the dry air. You think that because I'm not a Florida resident, and so I give up my Florida residency, there's no question, I go out, register to vote, do all the things that we think about, that then I was a member of the class, but now I've lost that. In other words, you're not focusing on the date that the disease manifests itself and saying, was the person a Florida resident on the day the disease manifests itself? You're adding an additional requirement that you had to be a Florida resident at the time the disease manifests itself and have held on to that status until the day you die and or November of 96.
Correct, Your Honor. And I think in terms of the language of the Florida Supreme Courts who presently suffer, have suffered, or have died, they're essentially speaking to three different groups of people. And for Mr. Bishop, it would be have died. You could use that language if you wanted to parse it the way that appellant is trying to parse it, to say that someone who was in Arizona, got a smoking-related disease and otherwise met the class membership definition, and then was cured through treatment, and then later moved to Florida. Well, you could say that person had, someone who have suffered from a smoking-related disease and might otherwise meet the class membership requirements. But that certainly is not a member of the class. Here, when you're looking at someone who's died, you use have died language.
If we were to reverse the summary judgment, do you think that the individuals, Mr. Bishop's membership in the class then becomes an issue of fact for the jury to determine?
I believe it could be tried, yes, Your Honor. We think that the record is undisputed.
Assuming that it's not a summary judgment for you, and it's not a summary judgment for them, that unless you concede he's a member of the class, it would just become a fact issue for the
Correct,
jury.
Your Honor. And plaintiff appellant did not actually move for summary judgment on either citizenship or residency below. And I do think that, speaking of citizenship and residency, I think there are a couple academic arguments that are going on in this appeal concerning whether it's citizenship and residency or citizenship or residency, and considering the specific test for residency. Because while it's still our position that you need to meet both hurdles, and it's still our position that residency would be legal residency, there is no dispute that under any of the definitions of residency that is found in any of the cases, if you have moved away with no intent to return to a state, that you have given up, you've given up pure residency in Maldonado, you've given up legal residency in Snyder. Now, the other issue raised on the appeal by appellant is the quashing of a 30B6 or 1.310B6 notice. Again, that's something that could be taken up if this court were to reverse by the trial judge upon a more specific notice by plaintiffs that gives more particularity as to the topics in which they seek to depose any corporate representatives, and that's something that could be taken up.
And your position on that is that they were not denied the opportunity to depose those witnesses. It's just that your objections were sustained, and based on the fact that the notices were overbroad. So they still, if we don't do anything and it goes back, they would have an opportunity to renotice those depositions.
Correct, Your Honor. And that was squarely within a trial court's broad discretion on discovery to look at a notice and say you've got to be somewhat more specific in what you're intending to ask of the corporate representatives, because then that lets us do our duty under the rule of preparing the corporate representatives to actually have the information to give over the discovery.
Let me shift gears and ask you a question on your cross appeal. I'm having a hard time understanding precisely what the judge's ruling was. When I look at the transcript, he says something to the effect of, if I was writing on a clean slate, I'd probably agree with the 11th Circuit, but I suppose I'm bound by the Martin decision. But the actual order that's entered just says denied. You file a motion for a determination of the preclusive effect of the Engel findings, and his order just says denied. Mm-hmm. And I'm not sure what that really means. I'm not sure what position the trial court really took.
Well, that might be somewhat our fault in our styling of our motion. Our motion was actually seeking for a determination that the findings could not have the broad preclusive effect that appellants seek to use the findings for. If you take yourself back in time, at the time the Martin decision was the only DCA guidance on the impact of the findings on these cases. So at the time it was clear that Judge Ployce was bound by the Martin decision.
So let me just make sure I understand. I'm sorry to interrupt, but you think that his order actually is a ruling that it does, that the plaintiff wins the day on that?
Correct, Your Honor, that he was bound by Martin and bound by Martin to deny our request to prevent the preclusive effect of the findings from going beyond the actual text of what the findings state. Now, since Martin and since that order in this case, there have been several other appellate decisions, one of which appellant filed a notice of supplemental authority, has now been set for argument in the Florida Supreme Court, and that's the Douglas case, which is set for the beginning of September to be argued. So I didn't want to spend a lot of time talking about
I think
issues.
we probably all agree that if the case were to go back, whatever the Supreme Court ends up doing in the case that they've accepted jurisdiction on is going to be the answer, and it'll be whatever it's going to be.
Correct, Your Honor.
Their chores are this big.
And certainly, so if this court were at all inclined to reverse, we would think that waiting for Douglas would be proper to do in terms of the effect on our cross appeal.
So if you were writing an opinion on that, what is it that you would have us say that would leave that issue open?
Well, I think that holding any decision would be an option that this panel, if it wanted to, could take, so that this panel could see what the Douglas decision is, and then...
And we don't generally hold opinions that long.
And so the other thing that you could do is provide direction to the trial court that any, and I don't think just under regular scheduling it would happen, but that any trial in this case should be guided by the Florida Supreme Court's eventual decision in Douglas or any future appellate guidance. This court also has a case that is set for about the same time off a jury verdict.
So you're not suggesting that we certify the same question or anything like that? You just...
That's certainly an option that this court could do by the time, and again, it depends on the timing of this court. You certainly could certify the same question up to the Florida Supreme Court, and it could sit there while Douglas does. I'm not sure there's a benefit to that as opposed to holding your decision if you're going to simply certify the same question. But that will be an option for the panel as well. It all boils down to different ways of getting to that same place. If the panel has no further issues on the cross appeal, thank you.
Thanks. You've got about 3.5 minutes, 3 minutes and 45 seconds.
Ms. Humphreys, could I steal just a few seconds of that and ask you on reflection, don't you agree that Judge Boyce's order finding that the discovery was, the notices were too broad, it really shouldn't be reversed, should it? You can always re-notice of those depositions and take them, so wouldn't you agree that his order was correct in that regard?
No, I don't, and for two reasons. First of all, this case is broad. This is 50 years of conduct. So the question is whether or not the notices related to relevant evidence. And of course, the definition of relevance is different when you're talking about discovery than when you're talking about admissibility.
But one of the problems that I have is that on the one hand, obviously as a plaintiff, you understandably want to take advantage of all the Engel findings. But on the other hand, it seems like the discovery is intended to trot out all of the negative information that, presumably you're going to want to put out in front of the jury so that they're really upset with the tobacco companies, and that may be, maybe right or wrong, but it doesn't seem like you ought to be able to take advantage of the Engel findings and at the same time trot out all of the evidence essentially that the Engel jury heard and get the jury all fired up against the, I guess fired up's not a good word in a tobacco case, but get them all emotionally charged up against the tobacco companies. That seems to me the conundrum that Judge Ployce was probably struggling with.
For some reason, the way you phrased it really kind of helped me synthesize the issue. This is not like bifurcating a liability and a damages trial, because when you do that, the defendant's always going to say, well, why are we talking about liability again? You're just trying to fire up or get the jury emotional so they give big damages. This is not that. Remember, the findings relate only to the defendant's conduct, and the findings relate only to the harmfulness and addictiveness of the cigarettes, but we still have the individual issues. Primary of that is causation and comparative negligence. And the way the defendants, remember, these cases are unusual. By virtue of them being Engel progeny actions, we have had multiple trials over and over. I've participated in many of them, providing appellate support at the trial level and handling appeals. I can tell you, Every single one of those trials, it's more than 50 now, the defendants litigate these cases as an either-or. They tell the jury it's either addiction or it's choice, and we say it's choice. And how do we counter that? The way we counter that is to give the jury the context of that decision. Now, let me be more complete. What we say, in all of these cases, we affirmatively plead both. In every one of these cases, the plaintiff affirmatively pleads, and this is very unusual in my years of doing personal injury litigation or appellate work in personal injury litigation. In all of these cases, the plaintiff affirmatively alleges in the complaint some level of comparative fault with the defendant's fault. And so we try these cases saying we know we had some role in this, the plaintiff, but it was in conjunction with them, and jury, you have to apportion.
Well, and neither you nor Judge Orfinger mentioned punitive damages, but aren't you seeking those, and don't you need this information to, quote, fire up, close quote, the fact finder on punitive damages?
I should learn to lead with my best argument. You're absolutely right. And that is, again, a difference between when you bifurcate liability and a damages trial. With a bifurcation of liability, you can also at that point have a determination made as to entitlement for punitives so that the amount and all of that happens in the second. But here, the Florida Supreme Court expressly held in Engle that punitive damages has to be determined for each particular plaintiff.
Is there then no judicial economy at all in going through this entire process if we're going to have to do discovery all over again on everything related to the defendant's conduct that went into the Phase 1 trial?
Well, that's a...
And then try to get, I mean, I don't see any judicial economy in bifurcating it if we just rediscover and retry the same issues again.
It's a great question.
It is a great question, Judge. It is a great question, and I would like to transcribe that and take it to trial court. We have argued again and again, and some trial judges have agreed, let us just use the depositions from other corporate representatives, and let's jointly take them. But the defendants resist that aspect in trial litigation, and the reason why is in the Engle record before you, and there is a document written back in the 80s by the defendants where they state that their strategy for litigating these cases, these smoker cases, they quote patents saying, we'll basically, beat the bastards down. In other words, we are going to make this so difficult for the small plaintiff firms who are litigating these cases, we will file tons of motions, tons of papers, and fight against everything. And so when we have attempted, we're small firms, we would love some economy, please. When we have attempted to do that, it has been resisted at the trial level by the defendants. So that's why that didn't happen. And specifically, they won't allow that deposition to bind them in our particular case.
Accepting all that, your notice could still be too broad, couldn't it?
Well, and the reason I disagree while it is still too broad is this is information that relates to the 50 years of conduct. Now, one of the things that they particularly took issue to about is concealment. If you go back into the Engle decision and dig in, you'll see that that original cause of action asserted 2 fraud counts. One was fraudulent misrepresentation, and one was fraud based on concealment. The Supreme Court held that the misrepresentation was too person-specific because reliance is required for that. It's not. Specific reliance is not required for concealment. How can you say, I relied on the statement that you never said? So to the extent that they talk about specific brands, all of that is relevant to the concealment plan. The fact is, for 50 years, the tobacco companies marketed these cigarettes as healthy. They did it with a wide variety of cigarettes. They did it using light cigarettes. They told people, hey, guess what? If you smoke our light cigarettes, if there is any possibility of toxins entering your system and being harmful, it's less because they're light. No, that's not so. The documents of the defendants themselves, remember that they engaged in extensive amounts of scientific research, established the converse. Sure, those are light cigarettes regarding maybe the tar content. But because they are light and because the people are addicted, the defendants' documents established unequivocally that people compensate. So they smoke more of them, thereby not deriving any health benefit.
Thank you very much.
Thank you.
So you just want to agree with everything that you've done?
Well, if I might have leave of the panel to address the 1.310B6 deposition issue, even though it's my rebuttal.
Sure.
The question is not necessarily the precise relevance of the discovery of the sought. There is a burden weighing that goes on when a trial court grants a motion for a protective order, and that burden weighing does, as we've raised in our papers and raised below, have to take into account appellant's decision to invoke the Engel findings and use the preclusive effect that they've attributed to the findings.
Let me ask you this. If you end up winning in some form or fashion in the Supreme Court on the issue of the preclusive effect of the Engel findings, so that it, based on due process or whatever other concerns, they have very limited preclusive effect, then wouldn't you agree that the notice needs to be that broad? The topics on which the plaintiffs need to conduct discovery would certainly be as broad as set forth in their notices in order to address all the issues that would then need to be tried.
Well, the scope of any deposition might need to be that broad.
Okay.
But the type of notice needs to be reasonably particular so that we can educate the witness on what if plaintiff is going to ask about 1962, a specific document in 1962, so our witness doesn't pick it up and say, I've never seen this before. So you can have a broad deposition that still has reasonably particular notice of the specific topic areas within that broad topic you're going to ask about. And I do want to clean one thing up from appellant's argument. I'm not going to specifically respond to accusations of scorched earth litigation, but we did. It's in Philip Morris USA's motion for protective order at page 7. I don't have the record site, but it certainly is in the record. We memorialized our attempt to meet and confer and offer prior corporate representative depositions that we thought covered similar topics to those that plaintiff was attempting to ask about, and we offered to produce those to them so they could review them and see if they needed additional discovery. And certainly more, there have been even outside of Florida additional depositions since the trial court's order in this case. And again, if this case were to go back down, we could renew that process of attempting to meet and confer with plaintiffs as to the specific discovery that they seek and attempting to fill that through potentially other corporate representative depositions.
You would agree as a practical matter that taking these same people, there are only a limited constellation of people that have this knowledge, right? So taking these same people, their deposition hundreds of times for hundreds of lawsuits, that is a practical matter. That can't work, can it?
Oh, absolutely, Your Honor. And what we're doing with the 1.310B6 deposition is we're giving the position of the company. And certainly the position of the company is not going to change from case A to 1 week later case B. So certainly we don't think that there should be duplicative 1.310B6 deposition.
And the same would be said for experts for each side, wouldn't it? I mean, there are only a limited number, really, of experts in these matters, and how many times can you depose the experts that the defendants use and the experts that the plaintiffs use? Hundreds of times? I mean, does that work?
Well, typically that the base opinions of the expert might not need to be rediscovered from case by case, but each case is an individual smoker, and unlike the company's positions, the expert's opinions might be different as it relates to a specific smoker within the context of a specific case.
They really never are, though, are they? They don't even look at the facts of the individual smoker in a particular case. They just give the same, quote, generic, close quote, testimony, most of them.
And I know that in a lot of cases, the experts do not get deposed with case-specific testimony, with case-specific depositions, but I think due process in the Florida rules would give defendants an opportunity, even though the opinion is generic, to test that within the specific case.
Thank you, counsel. You've exhausted your
But
time.
now that you've exhausted your time, I didn't want to take up your time with this because I'm just curious. But do you know how many Engel cases there are pending in Florida? Do you have any?
Within Florida, both state and federal courts, approximately 8,000.
Okay. Just curious. Thanks.
All right. Thank you both. Well-argued case.